Very good morning to you, Desiree, and to our viewers at home. Well, of course, breaking news from the Pietermaritzburg High Court. The application by the former president and his co-accused French arms company Thales for a permanent stay of prosecution has been denied with costs immediately after handing down the ruling by the three judges here in the court. As the former president left, an attempt was made to get a comment from him. He has refused to comment at this stage, and so it means that on the 15th of this month, which is next week Tuesday, that was the holding date for the trial. That means that the case then will continue. Of course, there is that matter of the appeal, having been unable to get any comment from the former president on whether or not that is the legal route that he is going to be taking. But now let me bring in our legal expert, Advocate Jackson. Advocate, thank you so much for joining us. You were listening through to the judgment as it was handed down. Very short, as you had said earlier on, or predicted earlier on. Just take us through step by step what the judges, the handing down of the judgment.
Yeah. Well, the first thing I under to note with the judgment, the very important thing to note is that it was a unanimous judgment, which means that all three judges concurred with each other in relation to the judgments, the different orders that were taken. There were ancillary orders in relation to the condemnation application by the state being confirmed with no orders to costs, as well as the order in relation to the striking out for the state being confirmed. In terms of my notes, with no orders to costs, and then the application by the former president to strike out was dismissed with costs. The letter that the advocates Kakane, counsel for the former president, introduced into evidence, or attempted to introduce into evidence at the 11th hour on the last occasion, that was also denied, dismissed with costs. But the two major findings by the courts, which are the main applications on behalf of the both accused, was also dismissed with costs, including the cost of two counsel where employed. Yes. All
right. I suppose now the big question is, and we know we spoke about this earlier on, what is likely to happen? You did say that you foresee any of the sides, and in this case now the losing side is that of the former president and his co-accused, that the possibility is they're going to want to take this matter on appeal.
I still maintain that view. As matters stand, you would have noted, of course, that you've alluded to, that the judgment, only the order was read out. Now, that does not necessarily mean that the reasons weren't given, and the reason for that is because had the court withheld reasons, the order would have been made that the parties need to apply for the reasons. In the normal course, in terms of the rules, the parties would have to do that within 10 days, but because he didn't make that specific order, we know that the reasons are already been handed down. In those circumstances, should the former president as well as Thales wish to ask the court for leave to appeal, they'd need to do that in the next 15 days. In terms of the rules, but as matters stand, should they not appeal, which I don't think is not going to happen, the trial proceeds. We'll definitely gain clarity on the trial date as to which route they intend taking. They might ask for an adjournment for that purpose, because it's still within the 15 days in which they have recourse to ask for leave. But I'm confident that the former president as well as Thales will want to approach the Supreme Court of Appeal to appeal the finding of the court today.
So, as you're saying that a leave to appeal, obviously that application would have to be formally be made in this quarter, so that will not necessarily be listened to on the 15th, which was the holding date for trial. Would the court then have to set another date for that application for leave to appeal?
Okay. The unsuccessful parties has 15 days to ask for leave. A court hearing leave is the court that heard the application, in this case the three esteemed justices. If that is the route they will then it would follow that the trial court would adjourn the matter so as to accommodate the litigants if they should they wish to appeal the matter, and that is in fact what will happen should they wish to appeal the matter, because if they have 15 days in terms of the rules, logically the matter on Tuesday falls well within those 15 days.
And obviously, advocate, if they do, then as you're saying, that the likelihood is that he might, or former president and his co-accused Tarlis, will most likely appeal this matter. We are looking at how, I mean, that means that it's still going to be quite some time for this matter then to the SCA for the appeal.
Yes, that's quite correct, Ayanda. Should the former president as well as Tarlis in fact appeal the matter, the court, the three judges that heard the application would only grant leave to appeal if they are compelled, that if there are compelling reasons to do so, or they are of the belief that if another court could find a different order. Should they choose to ask for leave to appeal and not get it from the three judges, they would then, should they still wish to, they would petition the Supreme Court of Appeal, and they'd have to do that within a month of having been denied leave to appeal by the three judges. So all those processes do take a bit of time, and there's the logistical implications as well. So quite correctly, as you pointed out, it would still be a further wait going forward. But at very least, it would be a month and a half going on 2 months. Yes.
So in terms of the state, obviously, this is good news now for the state. Of course, they will then have to wait for the accused or the applicants in this matter to see what legal recourse they're going to take. But this is this is a victory for the state. Well, at this point.
Quite correct. In fact, as far as they are concerned, the trial proceeds on Tuesday, unless anything is brought forward by the accused to that effect. It was a victory for them, quite a thorough one, in the circumstances where the order that was granted was included the cost of 2 counsel were employed. That's quite a convincing victory. Yes.
Right. Advocate, thank you so much for your time. Advocate, they're giving us his legal expert, of course, on the ruling today, the Pietermaritzburg High Court handing down judgment dismissing the application by former President Jacob Zuma as well as his co-accused in the corruption case, and that is French arms company Tarlis. So basically it's saying that this means that unless a former president makes an appeal or appeals this judgment, this case will then go to trial. Of course, big news happening inside the court, but outside still, as we had said earlier on, that today we were not expecting any crowds, as the organizers of the support for the former president did say they did not have enough time to prepare. However, some of the leaders of the ANC here in KwaZulu-Natal, they were in court. We also saw the BLF leader Andile Mqiltama. He was here in court as well. We have not seen them leave, so we'll also try to just get their reaction. Of course, many of them, Desiree and Blaine, you'd know that from April, when the charges were reinstated and when the former president first appeared at the Durban High Court, they have consistently been here showing their support to the former president. And of course, often or not, after the court case, it did give us an opportunity to hear the side of the former president when he would leave the court to go and address his supporters. That has not been the case this time. There was an attempt to speak to him as he walked out of the courtroom and saying that he is not ready to comment. He has, of course, consistently said that he believed that this was a case by those who were hell-bent on seeing or on ensuring that he did not become president of the country. And he maintained, obviously, the political conspiracy, political interference in the matter. The other point that the former president did raise the last time was that this has been quite costly for him. In fact, he used the words that he had now been forced to sell his socks and pay his legal team. So quite damaging for him this time, in that the order is with costs. And so we will try at least to speak, see if we can get his legal team to get a comment at least from them on the way forward, or whether or not, as the advocate was saying, that he foresees them applying for a leave to appeal. But we are still here outside court, and we'll be trying to get as much a reaction reaction from the legal teams as well as those leaders of the ANC and from other organizations that had come out here today to support the former president. For now, Blaine and Desiree.
Ayanda, thank you very much.
Excellent work there from Ayanda.